Well, the pizza is on its way. So what we'll do is we'll get started, and then we'll have a little interruption when the fish is up so you can all get dinner. But we didn't want to have you wait any further. So I'm very, very pleased to welcome you on this snowy day, and thank you very much for coming to this presentation for the Center for Health Law Policy and Ethics here at the University of Ottawa. I'm really very delighted. I'm Jennifer Chandler. I'm one of the professors and members of the Center. And I'm very delighted to introduce you to my colleague Vanessa Grubin and to our guest, Erin Nelson from the University of Alberta. And I will just say a couple of quick words about them to introduce them and then get out of the way and let them start on their presentations. So Erin is a professor of law at the University of Alberta, Faculty of Law, where she's been a professor since 2000. A member of the Health Law Institute, situated at the University of Law at Alberta. Hello. And her research interests are at the interface of healthcare, law, and ethics, women's health, issues in reproductive health, and feminist legal theory. She teaches tort law, healthcare ethics, and law and medicine. And Vanessa Grubin is an associate professor and member of the Center for Health Law Policy and Ethics as well, here at the University of Ottawa. Her research focuses on the legal and ethical aspects of organ donation, as well as legal regulation of assisted reproduction. And she teaches an introductory course in health law and policy and a seminar on access to health. Erin and Vanessa recently co-edited the 5th edition of Canadian Health Law and Policy, in which I have a chapter too. Thank you, everybody, to both of you. And in fact, the book launch is scheduled for tomorrow at 4:30 in the atrium of the law school here. So you're warmly invited to come to that as well. So we'll start with Erin, who's talking to us about consent and organ donation.
Thank you, Jen, for that kind introduction, and thank you, Vanessa, for inviting me here to talk about organ donation. What I'm going to do is try to be brief. I want to leave lots of time for questions and discussion, and I know that we have already kind of limited time here. So I want to sort of touch on and raise some issues related to consent in the context of organ donation, and then we can see how we go. Now, is your preference to wait till after both for the questions? Is that how we're...
Why don't we see how the pizza arrival?
Okay, we'll see what the really critical issue here is when the pizza arrives. Okay.
Perhaps we can hold all the questions, but we'll see what happens with the pizza.
Okay, so I will just proceed on that basis. So there are some really interesting issues that come up from time to time in the context of organ donation. And I want to sort of frame this within the context of the sort of fairly, I think, imminent and urgent sense that we have now, that we do have to do some tinkering with policy or make some kind of policy change in this area, because we are constantly dealing with a shortage of organs, and we are looking for ways, creative ways, hopefully, and that will try to attempt at least to address the distinction between the supply and demand, or the gap between supply and demand for organs. So often when we start hearing sort of conversations and discussion about policy reform, one of the issues that comes up is the issue of consent, and whether we need to change or should change how we approach consent in organ donation to improve or increase donation rates. So that's kind of the overarching context in which I want to sort of consider the issue of consent. And what I want to start by doing is showing you some boring statutory material to just give you a sense of what the consent provisions look like. They're different across the country. There are some strong similarities. Some provinces have legislation modeled on uniform legislation, so those stronger similarities in. But many provinces have started to, over the years, change their legislation, so they're not all the same anymore. So I just wanted to give you a couple of examples of what the consent legislation says, and then talk a bit about how that works in practice. So Alberta's Human Tissue and Organ Donation Act, there are lots of provisions about consent in the Act, but this is the one I want to focus on. This is in relation, I want to be clear about this, to deceased donation. When we're dealing with living organ donation, the person that is donating the organ is available to give consent, and we don't have as much confusion or as many questions about who we need to get consent from in that context. So this is about deceased donation, and the section just simply explains that a person's tissue, organs, or body may be donated for transplantation, education, or research from his or her deceased body if a consent is given, A, where that person is an adult by the adult, or B, by a person in accordance with subsection 2. Subsection 2 then says, when a person dies or his or her death is imminent, if the person is an adult who has not given consent, and in the opinion of a medical practitioner, the person is incapable of doing so, then we look to a list of family members in order of priority. I'm not going to reproduce that list here. I didn't think that was necessary. So that's what Alberta's legislation says. This provision comes from the Ontario Trillium Gift of Life Act, so the Ontario Organ Donation legislation, which talks about how consent can be provided, again, when we're dealing with a deceased donation. So a consent can be given in writing, signed by the person at any time, or orally in the presence of at least 2 witnesses during the person's last illness, explaining that the person's body or parts can be used for the specified purposes. And this is subsection 4 sub 3, which says, upon the death of a person who has given a consent under this section, the consent is binding and is full authority for the use of the body or the removal and use of the specified part or parts. So it's, I think, a fairly clear statement, as is the Alberta legislation, that if the person has given consent, that consent provides authority for the use of that body part. The Alberta legislation says that we only would look to other people to obtain consent if the person who has died did not give that consent before their death. And just for a third example, this is the British Columbia legislation. And again, it's very similar to what the Ontario legislation says. The age is different. The age at which consent can be given is 19 instead of 16 in the Ontario legislation. And again, there's a clear statement in subsection 4.3 that on the death of a person who has given consent under this section, the consent is binding and is full authority for the use of the body parts. As lawyers, I think that we probably all would find that language very clear, very explicit. It's not a mystery who's supposed to give consent or when we would need to obtain consent from someone else. It seems fairly clear, at least to me, and certainly I'm willing to debate this, but it seems fairly explicit and clear that the idea is if the person, him or herself, who will be the donor of the organs or the tissues or whatever other body parts, has provided consent, that's enough for the medical team to go ahead and act on that consent. It's binding on them. They're entitled to go ahead on the basis of that consent, and it is full authority for those individuals. So I think the law is clear. Consent can be obtained either from the donor in advance of their death, or there are provisions in all of these pieces of legislation that allow for consent to be provided by a family member if consent wasn't obtained from the donor prior to the donor's death. This, though, it seems clear to me, and I think lots of others, is not, okay, my whole slideshow is not here. This is not how it's necessarily interpreted in practice. It's okay, I'm just gonna carry on. Oh, here we go. Sorry about that. I don't know how I managed to advance it all the way to the end. So I think that the law is clear in terms of what is permitted, how do we obtain consent. What is maybe less clear and creates some difficulty, arguably at least, is how consent works in practice and how, in particular, providers and organ donation organizations, or ODOs, which are also sometimes called organ procurement organizations, how the people who work with the family members of a person who is dying or who has died and who may be a suitable organ donor, how do these people interpret and understand the rules around consent, and what is the practice in that context? Because the law, again, I think is clear that if they have consent from the deceased donor, then that consent is full authority for them to go ahead and procure organs. That's not what happens in practice. And this has been a long-standing reality in Canada, and I think is maybe not terribly well understood. I think it is becoming better understood because there has been a lot written about it recently. But what happens in practice is not really consistent, I would argue at least, with the legal landscape. So in practice, even where a donor has indicated consent, the family members will still be approached by the organ donation organization and asked for their consent. And this can happen in slightly different ways in different contexts, depending on the jurisdiction and depending on their approach. But ultimately, the end result seems to be that if the family refuses to allow organ donation, refuses to say, yes, that's okay, we can go ahead with that procedure, because obviously my family member wanted that. If they don't say that, if they refuse to agree with that express consent, or if they refuse to give consent where there hasn't been one given, then procurement does not take place. The donation does not happen. And I became aware of this in the context of providing a workshop to HOPE in Edmonton. And HOPE is Human Organ Procurement Edmonton. I think that's what the acronym stands for. So they're the organ donation organization in Northern Alberta. And they are the people then who approach families of people who are very ill and dying, or who have just died, to talk to the families about their wishes, whether they knew what the deceased's wishes were about organ donation, and see whether or not they might be able to proceed with donation in any given situation. And I was talking about some changes that had been made at that time to Alberta law. And one of the arguments made by the policymakers, by the Minister of Health who presented that legislation to the provincial legislature, was that, it's noisy, whatever it is. One of the arguments that had been made was that we needed to change the consent provisions in Alberta law to make it clear that it was not necessary, where consent had been given, to also seek an additional consent from family members of the deceased donor or the potential donor. And I was showing the distinction in the legislation, and I sort of said, I don't really think there's any difference, even though the language has changed slightly, I don't think there's any difference in the legal effect of that language. Either way, it was clear before, and it's even maybe more clear now, that the consent of the donor is sufficient. And the people in the workshop from HOPE, and there were two different groups there. There were people from the Organ Procurement Agency, and also from the Canadian Tissue Centre, the tissue procurement organization. And the people from HOPE said, well, that's not what we do in practice. We ask the family if they will consent to organ donation, and if they decline, we don't procure organs. And I sort of probed, I thought, not offensively, just asked a few questions about why that would be their approach and why that was their sort of understanding of what they needed to do in practice. And the clear answer I got, and I did this workshop twice for two different groups from the same organization, and the clear answer I got both times from different people within HOPE was, it was our understanding that when the donor dies, their consent ceases to have any legal meaning or legal effect. And I said, oh, well, did you have a legal opinion that suggested that? And they said, no. And they looked at me like, why, that's just what we thought was appropriate. That's what we thought the law was. And I said, well, that isn't actually what the law is. The law says that it's binding and it's full authority, whether it was given prior to death, isn't important for your purposes. And I sort of likened it for them to a will, which we all understand is a legal document that is executed and signed prior to someone's death, and that takes effect only after their death, and the validity of it from a legal standpoint is not altered by the fact that they have died. And so we had a discussion about that, and the Canadian Tissue Centre individual who was at the first workshop said, well, actually our practice is as follows. We don't even, because tissue can be donated in many different circumstances than organs can, and you don't have to be necessarily in the same kind of reason for death or cause of death for organs for tissue to be donated as you do for organs. So a person could actually be ill and in the hospital and be approached about the possibility of tissue donation after their death. And the Canadian Tissue Centre people said to me, well, what we do is we talk to the patient, we ask them about what they would want, we tell them all the possible uses of the various body tissues that we could take from them, we ask how they would feel about various tissues being used, but we don't ask them for consent. That we just inform them, and then after they die, we ask their family member for consent. At which point I think that my jaw might have hit the table just out of sheer surprise that this would be the way it works. And I followed up with the Tissue Centre management, and they confirmed for me that that is their policy. And again, the theory seemed to be that they were concerned about the ongoing legal validity or legal effect of the wishes of a donor if the donor has died. And you know, I think that comes from a couple of places. It doesn't come from legal advice. I established that after I talked to a number of other people. I think, though, it comes from the practical reality that these organ donation organizations face, which is that they have no alternative but to engage with family to some extent. They can't ignore the family and just proceed with donation, even if someone has given consent, because they need to ask questions of the family, and they need, hopefully, to have the family cooperate in responding to those questions about the family's past medical, or the family member's past medical history and social history, in case there's information that hasn't found its way into a medical record that might affect the person's suitability as an organ donor. And so they have to engage with family. The other practical reality, I think, that speaks to why practice is the way it is, in spite of what the law, I think, quite clearly says, is that there is a really very significant and intense need for there to be public trust in organ donation programs, and sort of the sense of sort of a social program that we all can participate in and that is respectful and carried out in a respectful and manner, you know, that demonstrates integrity. And I think the concern that organ donation organizations have is that if they proceed without speaking to family, without making it clear to family that they have some say in what's going to happen or not, that they will lose the public trust, and that will irreparably damage these organ donation programs, and that would be, as you can all imagine, a terrible outcome, because then we would have even fewer organs available than we currently do. And so I think that those two realities really do influence how organ donation organizations proceed. I did suggest to them, being a lawyer in a room full of healthcare providers, I just wasn't very subtle, and I said, well, it would be really interesting to see what would happen. You know, these laws have never been judicially interpreted from the standpoint of the meaning of consent here. It would be interesting to see if you just went ahead, if you had consent from the donor without the family's consent, and then kind of watched what unfolded and how the judge, you know, if it came to litigation, how the judge would interpret it. And they looked at me with shock and horror. Like, there's just absolutely no way that is going to be attempted. So I think that, you know, that at least gave me a sense of, you know, some different perspectives in terms of what clearly seems to, the law clearly seems to say about what's allowed and not allowed, and what some competing concerns or considerations might be in terms of the practice around organ donation. How's my time? Do I have a couple more minutes? Okay, so I just wanted to talk a little bit about consent alternatives. So we've seen some literature, as I said, written about this practice of asking the family for consent and the family being able to override deceased donors' wishes. My own view about that, and I'm sure that this is informed by my background and my training in law, is that that would upset me greatly to know that, for example, I have registered as an organ donor and my family could simply disregard that wish, that if they didn't feel comfortable with it, ultimately it would be their wishes that would govern what happens. And so a lot of argument has been sort of pushing in the direction of suggesting that the problem, or a problem at least, with consent is this ability for the family to override someone's wishes after they've died. And, you know, maybe that is one of the problems, but another maybe dimension of this that we could think about is other consent models different from our own, and what happens in those other kinds of contexts. So our model is what I would call an explicit consent model. You have to give explicit consent to be an organ donor. In other jurisdictions, you can have a situation of, or a context of presumed consent. It's basically an opt-out model. You are deemed to agree unless you somehow express that you don't agree with donating your organs after you die. There's also a third option in between, maybe, that of mandated choice. So you don't have to participate or else opt out, or you don't have to specifically opt in to participate, but you are asked at a time when you're doing some kind of involved in some kind of process like renewing your driver's license or renewing your passport or some kind of document that you have to interact with government to an extent, or where you're required to make a decision. They're not going to tell you what that decision has to be, but they'll say, do you want to be an organ donor or do you not? And then that forces at least people to consider the options. It's not something that everybody thinks about on a daily basis or even a regular basis, and it's not the kind of thing that many of us are terribly comfortable thinking about at all, because of course it requires us to contemplate our own mortality, which for many people is not a enjoyable prospect. One of the arguments that's made in sort of thinking about how we might modify consent policy to better access organs for use in transplantation is that maybe we should move to a presumed consent model. These models seem to be useful, and often Spain is raised as an example of a place where the law is that of presumed consent, and they have very high donation rates in Spain. The interesting thing about Spain is that it's not that clear, actually, that the presumed consent model has anything at all to do with the increased donation rates in Spain. But a lot of popular media don't get into that sort of level of detail. Spain has had, since I think 1979, a presumed consent model. But it's not my sense at all that that model is relied on, really, to any extent. And ultimately in Spain, the family members of a deceased person are asked, just like they are here, whether or not they would agree to allow for donation of their family members' organs. And interestingly, in Spain, 85% of the time the answer is yes. There is a really, really high uptake, much different than what we see in many other jurisdictions. And what happened in Spain about 10 years after the adoption of the presumed consent laws was that Spain put in place a national organization aimed at coordinating transplantation activities, and they really focused on creating an infrastructure and training for people involved in transplantation work, healthcare providers involved in this area, and that seems to have made an incredible difference. So I will wrap up by saying, maybe what we should do, instead of worrying about getting rid of this power that families seem to have to override the wishes of a deceased potential donor, is figure out how we can effectively work with families so that we don't have to ignore the reality of the need to engage with families to an extent, but we can still build on bringing that donation rate up in more creative ways. Thank you.
So I'm going to talk about a topic that's slightly different, still in the area of deceased donation, but an issue that's relatively new following the legalization of medical assistance in dying in Canada. Because we're pressed for time, I'm going to assume that we're all fairly familiar with the MAID framework in Canada, and I'm just going to dive right into the issues around organ donation. But certainly in the question period, if there's questions about that, happy to address them. So when MAID became law in Canada, one of the questions that arose was whether organ donation would be permitted following MAID, and if so, how that might happen. And it, what didn't take long for there to be, for consensus to grow around the fact that yes, indeed, organ donation should be a possibility following MAID. But the question then was really, how would that be implemented? What would that look like? And what might the variations between the provinces look like? And so there are a number of us, Jennifer Chandler, who's here as well, have been doing some thinking about organ donation following MAID in Canada, and actually the organ donation organizations, the ODOs or the OPOs, have also been doing quite a bit of work in this area. And so today what I'm going to talk about are some of the practical and ethical considerations that arise in this context. I should note that a number of these questions also arise in other jurisdictions where euthanasia or assisted suicide is legal and where organ donation is practiced. So we do have some other jurisdictions where we're able to draw on the way in which they've implemented organ donation following MAID. So in terms of some of the ethical considerations that arise with respect to organ donation following MAID, these ethical considerations apply to a variety of the stakeholders in this context. First and foremost, of course, are the patients. So what some of the most important ethical considerations when we're thinking about MAID following organ donation is a concern that a patient who is choosing to undergo MAID isn't pressured or coerced into donating his or her organs. Or alternatively, that they may, someone might choose to end their life earlier to opt for MAID in order to donate his or her organs. That concern is particularly acute when a patient may know someone, a loved one, or a family member who is in need of an organ. Patients might also feel pressured to consent to donation because they might feel that their physician or their healthcare provider is in favor of donation, and they might feel pressured as a result to donate. So there's some concerns about ensuring that we have informed consent and avoiding some of these external pressures when we're in the process of considering organ donation after MAID. There are another series of ethical considerations that arise with respect to medical staff and healthcare professionals in this context. So quite a bit of the literature that's come out, certainly in Belgium and the Netherlands, has really focused on how difficult this process is for healthcare workers. Because many of the patients who are opting for MAID obviously are able to communicate and spend time with their healthcare providers and potentially the coordinators who work with the organ donation organizations. And so there's concerns about this emotional process, and how do we build in those concerns into the practice around organ donation after MAID. Another area that's been particularly contentious is around conscientious objection, concerns that a healthcare provider might conscientiously object, whether it's, for example, one of the coordinators around the actual MAID process, or it might be as far down the line as the physician or the healthcare team who would be accepting an organ from a patient who has opted for MAID. So again, there's competing views in this context. Some have taken the position that healthcare providers there's really no room for conscientious objection in this context, and that if a patient opts for organ donation following MAID, that the physician or the healthcare team who would be receiving that organ really doesn't have a legitimate basis upon which to object. But there is a strand in the literature that speaks to the importance of respecting a professional's autonomy and their liberty to object in this particular context. Of course, that similar concern arises for recipients. There is some question about whether an individual who is on the wait list, who is waiting for an organ, whether or not that person should be advised that the organs that have become available or the organ that has become available is from a patient who has chosen to end their life through MAID, or not. There's when we think about organ donation outside the context of MAID, we ordinarily do not advise the recipient how the donor passed away. So for example, if a donor passed away as a result of suicide, that's not something that we tell the recipient, and thereby would not have an opportunity to object or not choose that organ. So those are the ethical considerations. There's also a number of practical or logistical considerations that arise when we think about organ donation, about the process of organ donation after MAID. You know, when we're thinking certainly about patient-centered care, especially in the context of MAID, one of the most often for some patients, one of the most important considerations is that they want to pass away at home as opposed to in hospital. And if a patient is going to choose organ donation, it becomes very difficult, if not impossible, to respect that wish. We really do need that person to die in hospital in order for the organs to be removed shortly after death. Another concern that arises certainly from a practical perspective is you know, the patient, if the patient wants to choose organ donation, that patient will need to undergo additional testing, which will require additional steps in that, you know, fairly limited time that person has before the MAID process. And so we want to think of ways that, you know, really reduces the burden of those screening processes, as well as any potential premortem interventions. So, for example, heparin is often given for organ donation, whether that is consistent with how the patient sees their end-of-life care. Certainly in terms of the practical considerations from medical staff and healthcare professionals, when thinking about organ donation after MAID, there's a real need for increased cooperation between healthcare providers and institutions who are responsible for end-of-life care. So for example, in the Netherlands, there's a reported case where an individual who was choosing euthanasia really wanted their own GP to provide end-of-life care, but he didn't have privileges, and also wanted to donate organs, but the physician didn't have privileges in the particular hospital. And so the hospital made an exception, granted the physician privileges, and it's a very nice example of how that coordination and collaboration can really facilitate these kind of processes. In addition, and I know we're pressed for time, so I'm going to zip along here, there's a real need for support or debriefing mechanisms for professionals in this context. As I mentioned, these healthcare professionals find these cases quite difficult, and so ensuring that there is some sort of debriefing process that occurs is critical in this context. So in terms of the practical considerations that arise with respect to when patients are approached about organ donation, this is something that's sparked quite a bit of discussion in Canada. Should this be done on a routine basis? So every individual who is opting for MAID, should that individual be approached about the possibility of organ donation, or should we leave this up to an individual to ask? So this is the difference between, for example, what we would call routine request or a patient-initiated request. The literature is quite divided on what the right way to do this is. What we've done in Ontario is and in a number of the other provinces in Canada, is that we treat these cases as a routine request. And so every patient who is contemplating MAID is approached by the organ donation organizations. The other question when we're thinking about approach is, well, who should be asking? And again, there's some question about whether, you know, the family doctor or the physician who is providing the end-of-life care and who has a relationship with the patient should be asking, or whether it is someone that's a bit further removed from that process, someone from the ODO. And as I mentioned, in Ontario, we've left that to the ODOs to do. The final point that I just want to address is that, again, raises quite a bit of controversy, is around directed donation. So directed donation occurs when an individual directs or advises who should advises the ODO who the recipient is going to be. And there are a lot of concerns about directed donation in the context of MAID. Obviously, there are concerns about the patient's motivation for MAID, if they're asking for their organ to go to a particular person, especially if it's a loved one who is in need. There's concerns about coercion and the reasons underlying the patient's desire to undergo MAID. But there is certainly an argument to be made that directed donation in these contexts maybe should be respected. This is allowing for organ donation after MAID is really, the reason we do that is to promote patient autonomy. And so are we artificially, or are we undermining that patient autonomy by precluding individuals from directing their donation in these particular circumstances? So I see that we're at 1:45. I'm going to stop there. I have a few slides about what's going on in Ontario, but I've alluded to that already in my comments. So I think Erin and I will take some questions. And as I say, we've got about 15 minutes or so.
Thanks. I have a few questions, but I'll start with one for Vanessa, and then I'll stop. I will ask one. Unless nobody else. Vanessa, I just wanted to pick up on the first practical issue that you raised in regards to organ donation post-MAID, and so the point that it makes dying at home impossible.
Difficult, yeah.
Or difficult?
Pretty close to impossible. There's, as Jen knows, there's sort of one case where this has happened, but it's quite difficult.
Oh, okay. Yeah, I mean, it makes sense. I don't know anything about about the logistics, but it strikes me that could also be an ethical issue, because I would imagine that many, if not most, patients interested in MAID would be at least in part interested in it because of its potential for preserving, what we call dignity, or just a sense of comfort and togetherness of family, being in a place that's not as horrifying as a hospital room in your last minutes. And if that is, if they are also very interested in helping others by choosing MAID, that's going to present attention, and it's probably going to, I would imagine, significantly reduce the number of people who would be donating organs, and so the number of available organs, and making the experience of those who do choose to go ahead with it much worse. So I was wondering, is there an interest in trying to make the home donation easier, or setting up hospice areas of the hospital that could also allow for donation?
Yeah, so I think you've really hit on two possibilities. I think in terms of the potential for opting for MAID at home and then undergoing organ donation, there is sort of one reported case around this, but it's extremely difficult. It's really not a realistic way to build a system. I think the second example that you've provided in terms of providing this kind of care in a hospice setting, or in a more, a less, as you say, horrific kind of room, but no, a less sort of sterile and cold kind of room in the hospital. I think that's certainly a way to address the concerns that patients have around opting for MAID at home, while still allowing them to choose organ donation. And so, I know at the Ottawa Hospital, for example, that they have tried to make the area of the hospital where the MAID procedures occur, making that more comfortable, more hospitable, less clinical, and more sort of family friendly for providing the MAID procedure. And so that would certainly be a way that we could hopefully address some of these concerns.
Thank you for the presentation. And I guess it's a question of numbers as well. In terms of MAID, a lot of people that are asking for MAID are, cancer, patient from cancer. you know, where it's, you know, not possible to imagine that they can generally donate organ because you know, their organ are too not as well maintained. So do you have an idea of the numbers that it might represent?
Yeah, so in Ontario, thank you for the question, Michelle. In Ontario, 2017, thank you. 26, we had 26 tissue donors. 26 donors in total. I believe 2 of them were organ donors and the balance were tissue. But you're quite right. So, and you know, when you look at the statistics of who is undergoing MAID, a large percentage of that number is patients who have cancer or some other sort of disease that precludes them from organ donation. But we still do have a fairly good number of patients who have neuromuscular degenerative diseases who are opting for MAID who would be eligible for organ donation. And so it's out of that pool of people that, you know, certainly organ donation is a possibility. The other reality is that it is possible that the categories of people who will be eligible for MAID may expand. So right now it's quite narrow, but if we were to think of some of the other categories, for example, individuals who are suffering solely from a psychiatric condition, mental health condition, that would again, those individuals may be eligible to donate organs.
I think it's worth noting also that people with cancer can donate tissues.
Tissues, yes, absolutely, yes. So patients who have,
Well, and the timing isn't quite as critical, right?
Right,
So
right.
that might be a situation where we could get home.
home, and then the tissue donation could happen after the fact.
Just in the
That wouldn't do
context
as
of
much.
allocation of resources
Yeah.
limited, I guess, you know, the number counts in a way because.
So first of all, thanks for the presentations, and which I think are very timely. I would like to ask Professor Nelson to elaborate. I missed the very first part, so maybe you already did elaborate on the presumed consent practice. Okay, because as you touched upon at the end, my understanding is that the tendency now in continental Europe is presumed consent, which I understand is affected or implemented with an opt-out clause. So people have to declare they opt out at, for example, the point of obtaining a driver's license or renewal, which you might also know in Europe, a person gets a driver's license for 20 or 25 years, so it's not an annual, you know, it's a kind of long term. So the whole point is that this positive assumption of participation allows a planning and practical effects that serve a public interest in better health care, essentially, longer life and so forth. So that's the kind of philosophical approach to it. So I was a bit surprised when you mentioned that in Spain, actually they don't follow that. They nonetheless, I don't know what the actual practices are, but for me, it seems a prima facie sensible approach, as opposed to here, or in the Anglo-Saxon practices, because my expectation is that technology is going to continue to improve our ability to draw from or use organ and tissues and so forth to assist the well-being of others. But the consent element is going to be a sticky one. So hospitals and everyone's going to be not even ramping up because they're going to be so burdened by the consent. So what's your view on the kind of approach? Because I'm rather persuaded by the continental Europe tenets.
Yeah, I mean, my own view, I think, has changed over the years. I used to be a little bit alarmed at this notion of presumed consent, just because it is potentially a significant interference with autonomy.
Yeah.
What my understanding is, in most countries that have a presumed consent model, do still raise the issue with the family at the time when it would be relevant, so when the person is imminently dying or has just died, and still seeks some sort of agreement or consent before they go ahead, even though the law would permit them, in theory at least, to go ahead without doing that. The most recent, that I'm aware of, the most recent jurisdiction to adopt a presumed consent model is Wales. And it will be interesting to watch what happens there, because they have said the family will be involved, but I think what they mean by that is something quite different than the practice has been in continental Europe. I think they will be informing families as opposed to asking families for consent. They've only had this model in place for a couple of years though, so I don't know how much data there is yet to really assess. I think, in general terms, I think it is a concern that we will have to address to an extent, but I don't know that presumed consent is necessarily the answer. I think many of these countries that have presumed consent models also have really different demographics and very different rates of death in ways that would allow for organ donation than we do in North America. We're very lucky in that way that we don't have as many people dying, for example, in motor vehicle accidents. And so, the sort of picture is really more complicated than it might seem at first blush. And so the consent issue is definitely a piece of the puzzle. I don't think that there's only one way to approach that problem. I think we may have solutions, even if we keep an opt-in model, there may be ways we can work better in that model.
I'm hoping perhaps trying to see if there's some kind of intersection between the two presentations. And I'm wondering if we've ever thought about, or I don't know what the situation might have been in the organ donation main context, how the family's reaction in that situation is like. Whether or not, has there been disagreement in terms of, if the patients in that want to donate after May, has family said no? Have you encountered that yet? If not, perhaps is there something about May that we're doing where there's more discussion between the family members and the patient about having to go through the decision-making of the May process already that involves more dialogue, and perhaps there's some lessons we learned in terms of talking about consent for donation in that context?
Yeah, no, that's a very interesting point. So there hasn't been any work done yet around family experiences with organ donation after May, although it keeps popping up. This question keeps popping up. So somebody had better get on it. There aren't a lot of people, as you see from the numbers, there's still a fairly small number of people who have donated following May, but it would be very interesting to hear what their family, how their families have experienced that process. And I think your intuition is right. I suspect, although I don't know, that families are more involved in the discussions around what end-of-life care is going to look like, and organ donation being a component of that. And so maybe I'm sure there are lessons to learn about what those discussions look like and what those conversations look like that we could use in other contexts as well.
Well, and I think just to add to that, one of the main concerns in the context of families being approached to give consent to organ donation is that it's a terrible time, it's a tragic, traumatic situation that has led to that request that you made, and if there hasn't been any sense, that this was needed to be talked about in an imminent way, often it isn't talked about, whereas in the context of medical assistance in dying, there is an openness of discussion to a large extent in many families where this is going to take place. So I think that just lends itself maybe to opening other matters for discussion, and I think in the context of medical assistance in dying, if a family is going to have an objection, their objection is going to be more profoundly to the medical assistance itself than to what happens afterwards. That's my guess.
I think whether it's the procedures or the consent, at that point of time, what is going to be crucial is the timing. The time of the death and the timing for the organs to be removed from the body.
Yeah.
So do you have any idea, because after the death immediately the deterioration starts, is there a timeline that organ could be removed, or does it depend from organ to organ?
So I am not a medical expert. I don't know the exact timelines for each organ. However, there's no question that if, certainly when we're talking about medical assistance in dying,
ideally that has to happen in the hospital. Trying to transport someone from home into the hospital to an OR to be prepped for that surgery is just not, it's just not feasible. So thus all the concerns about, you know, how do we accommodate people's wishes for sort of comfortable end of life care while still choosing organ donation. So I think we have time for one more question.
Yeah, thanks for both of these talks. Just really quickly, I'm curious about these conscientious objection cases in sort of made organ donation. Because are they really conscientious objection cases? Are they conscience driven? Like, I feel very differently about refusing somebody who says, I can't bring myself to do this, than somebody who says, this is wrong and shouldn't be done.
Yeah, I think that's an excellent question. So I think there is a very good argument to be made to say that, especially when you're talking, for example, about the surgeon who is going to be taking the organ and putting it into the recipient, that the argument in favor of conscientious objection, that's pretty tenuous. Because so just to be clear, the conscientious objection is around the MAID, right? It's around the MAID process. And that, those healthcare providers, that team is in no way involved in the actual MAID process of the patient. So I do think your question is quite on point. I do think it's quite an argument, or quite a stretch to say that that's a conscientious objection, but we have seen a couple of instances where that argument has been raised. So
we have a precedent in the discussion around whether, patients who go abroad and procure organs, buy them illegally, or get them in under circumstances where you suspect it's an executed prisoner and dubious legal process. And a discussion in our, I think the ethical guidelines here allow physicians to avoid doing assessments to facilitate that, or to, with notice, not take on patients upon return. And so the complicity would be in participating or benefiting from a practice that they object to.
but it's certainly a more tenuous argument than, for example, a healthcare provider who conscientiously objects to participating in the MAID procedure.
I think we've come exactly on the nose to finish at 7 o'clock. So thank you very much to our speakers and all of you for coming.